On.
Hey, everybody. Welcome back to the North Carolina Real Estate Show. Let me make sure my mic is close enough. I'm Tiffany Weber, a real estate attorney at Thomas & Weber in Mooresville, North Carolina. And today we are talking about, as a real estate agent, what do you need to know about family law in North Carolina? If you've seen any of our videos on Instagram, then we will be talking about something that Ryan likes to call spousal privilege.
Spousal privilege. It's what everybody needs in their life. They just need a little spousal privilege.
And let me just clarify, that's not what it's called. It's called, do you remember?
Marital privilege, marital status, marital.
Keep trying, you'll get there. Marital interest. So, I think really that's what this whole thing revolves around. Not every state has marital interest, so it can be confusing if you are not familiar with it, especially if you have clients that are moving here from other states or, you know, they own property and then they got married and then they're wondering why their spouse has to sign when they sell it. So we are going to get into that today. So Ryan, do you remember what marital interest is?
It is it's when you're married, both spouses have equal share.
Kind of. That's no, but your head is in the right place. So marital interest, it actually arises out of the right to inherit from your spouse's estate. So without getting too deep into the weeds on the laws of intestacy or when you die, what happens with your estate, the marital interest, just suffice it to say, arises out of your right to have a share in your spouse's estate. So a marital interest in the property simply means that, okay, if you are married and you own property, your spouse has an interest in the property, whether they were on the deed or not. So it may not be equal because that right comes out of the right to share in the estate. So it may not be 50-50. We're not going to speculate about what would happen in equitable distribution if you got divorced, but you cannot convey away the property without your spouse joining in and giving up their interest in the property as well. So that's kind of marital interest in a nutshell. Let's talk about, here's an example. It just happened last week. At the closing table, we have a seller who, at the time going under contract, was single. So he was the only person that needed to sign on the property. While being under contract, he got married. So at the closing table, we're going over all the documents.
Was he engaged during this?
Oh, I don't know. I mean, when we asked the marital status at the beginning,
You don't care? I was just wondering. This is more
No.
for my knowledge.
I think he did say that they, in his words, they ran off and got married. So I don't know if they were engaged or if it was kind of, last minute, like, hey, baby, let's go to Vegas type thing. But between the time he went under contract and when it was time to sell the property, he got married. So all of the documents were prepared as if he were a single man. So we're going over everything and we get to the marital status affidavit. And this is, why we have to do the marital status affidavit, to find out if you have a spouse that needs to join in conveyance of the property. And he goes, "Oh yeah, I am married now." And I was like, oh, tell me more. He's like, "Oh yeah, we just got married." I'm like, "Congratulations, that's wonderful. Please tell me she's not in Sweden." She was thankfully nearby, and I was like, "She's gonna have to." I went through all the. Did you have a prenup? Did you have a postnup? You have a free trader? You got any of these documents that would mean she doesn't have a marital interest in the property? None of those existed, so we had to get her signature on all the documents to sell. And thankfully, this person was cool about it. That doesn't always happen.
Be cool. Just be cool. Yeah. That's all that matters. Just be cool.
So, and it was a fairly simple fix that, it was okay for us to go get her signature on the documents before we were able to close. But yes, she did have to sign.
But you because of that, you guys made a situation that could have resulted in them not being able to close, him not getting his house on time. This was on a Friday. It was on a Friday. No, yeah, it was a Friday. So he was probably planning to move on the weekend. And, you guys kind of solved that situation rather simply because in your world, like, this isn't a big deal. Like, I can solve this problem as long as we're calm. Don't freak out.
Yeah.
Like, let's all be calm. We can solve this. Just This is all I need.
Now, the best case scenario would be that we knew about her before the closing, but that happens. It happens sometimes because people don't know about the marital interest. So they're thinking, uh, all the time, see it all the time over the last several years. I bought this property before I was married. Um, she or he should not have to sign anything when I sell. Well, that may be true. Do you have a prenup? Do you have a postnup? Do you have a free trade, or do you have some sort of do you have a quitclaim deed that severed the marital interest? So essentially, the how do you get rid of the marital interest? Either by signing a document or by not being married.
Hmm.
So there's no way for your spouse to have given up their marital interest if they didn't sign a document doing that. So if they say, "Oh, well, she doesn't have a marital interest because I bought it without her," or "He doesn't have a marital interest because I bought it way before we got married." That's not the way to get rid of it. Did your spouse sign something giving up their marital interest? If no, they didn't give it up.
Hmm.
Yeah.
So how can we kind of primarily make this for real estate
Mhm.
agents. That's who we're trying to help as much as possible. What can real estate agents say or do before the closing, before they go under contract, even to make sure
Mhm.
that they're going to have a nice smooth closing and you don't
Yeah.
have a whoopsie at Friday at 4:59.
Yeah. Number one is don't assume. We give talks at different groups of realtors to, go through like, hey, these are the hot topics or these are the things that we see. And one thing that I like to impress upon people is that who needs to sign is a legal determination, not a practical one. So if you are an agent who sees that your client, she bought the property as a single person, she might be married now, husband travels a lot, it's going to be difficult for him to get there. Oh, well, she's the only one on the deed, so she's the only one that has to sign. That is not the lawyer needs to make that determination. So, if you keep in mind that the signatures are a legal determination and should only come from the person who's making the legal determination, you know, sometimes you can't rely on the lender to tell you who needs to sign because they may be an out of state lender. They don't understand the marital interest. It may not be something in the state where they live and work 100% of the time. So, keeping in mind, whenever it's time to figure out who needs to sign something, talk to the person who can give you the legal opinion on that.
Just to FYI, that's the lawyer.
That's the
I
lawyer.
think
Yeah.
I think the
I think that
legal.
was obvious, but I shouldn't assume. The
It-
legal determination comes from the law office.
ah, gotcha. So
Yeah.
the other party that can be, or another party that can be helpful with this kind of stuff, is a family lawyer.
Mhm.
So what are some of the things that real estate agents can be asking the family lawyer? What should the family lawyers be knowledgeable enough to talk to the other real estate attorney or the realtor
Mhm.
about something that has to do with either divorce, separation,
Mhm.
or even post nup kind of stuff?
Well, one of the things that, we see that separates, like, a very good family law practitioner that deals with real property a lot compared to one that maybe doesn't deal with, the real property as much is their separation agreements will identify, okay, who's gonna take the tax liability when they sell this property? Who's gonna be issued the 1099? Sometimes what you'll see is spouses will, all right, I will give you the house, but you have to pay me a distributive award of X amount. So I'll sign over a quitclaim deed to you. You can sell the real property, but you're going to pay a distributive award to me of whatever the dollar amount is. Well, if you no longer own the house when that house is sold, you shouldn't get a 1099. So, um, addressing that say maybe that quitclaim deed doesn't get done in time to sell the property and the spouse has to execute the deed. Who is going to be responsible for paying the taxes on the sale? So that's one thing. And then also, you can tell a family law practitioner that deals with real property often because their deeds include the required language to sever the marital interest. So there's some statutory language that goes into deeds that a title company is going to be looking for when to decide if they're going to insure over that marital interest to make sure it was properly conveyed away. So we do see sometimes family law attorneys who they or their staff will draft a quitclaim deed and it doesn't have that language. And it could just be that they haven't had the issue of a title company saying, we can't insure over that. So, once they've dealt with that, they don't really skip it again. Other things like if you're listing property for a couple that's divorcing, if their separation agreement deals with the real property, but it's got a ton of juicy details in it that they don't want made public, you could say to them, "Hey, maybe talk to the attorneys and see if you guys could have a memorandum of separation agreement drawn up so that the memorandum could be recorded with the relevant things about the real property, but we don't have to talk about, your alimony or who gets to see the kids when. There's some details in there that you don't want made."
Yeah, that doesn't have anything to do with a transaction of real estate, and people don't need to know that.
Yeah. Yeah, so those are some things to think about. And then if you're listing a property with divorcing sellers, finding out what do they have in place. Because if it's nothing, then they both need to sign everything. Listing agreement, contract, all the closing docs.
If you have nothing, you have to sign everything.
Yeah, nothing equals everything.
Perfect. So with this, I mean, you see often this separation or new names or that kind of stuff. What are some of the things that could happen that would delay your closing or cause something not fun? Things that people don't like to see.
Well, sometimes people aren't truthful with us about their marital status, and we may find it in the title search or may even find it at closing. And then you've got a spouse that won't join in the execution of the documents.
What do you do with that? So, like, let's say you got separated, hate him. You don't like that guy, never going to talk to him ever again. Haven't talked to him in 8 months. You're separated, not officially divorced. He won't sign anything. What happens?
Well, depending on if you've got a separation agreement or, you've got the ability to force the spouse to sign through the use of the courts, assuming you don't have anything in place, then you could potentially be in breach of contract because you don't have the ability to convey clear title. Yeah, so it's take a bad situation and make it worse. Not fun.
No, not at all. With your people that you've also had the situation, this one makes me laugh. You've had the situation where they haven't been married for years and years and years, like multiple 10, 15 years, but they actually don't have the legal documents in place.
Oh, you mean like they broke up a while ago, but they never got divorced? Yeah.
So what happens then?
Well, sometimes those people have moved away and you can't track them down and you can't get their signature on anything. And I mean, it's the same thing. It's just maybe a little less animosity because you haven't, you're not actively hating the person, but now you got to track them down to get them to sign. So the end result is the same as if you can't get everybody that needs to sign, then you can't convey clear title to the property. Then you got a contract issue.
Interesting. Very interesting. Well, if anybody has any questions either around the family law and what happens with real estate, feel free to ask them in the chat. Also, if you have other real estate related legal questions or just questions about the law in general, or
not
being
legal
a lawyer,
questions.
being a lawyer,
we won't answer legal questions.
Tiff will do her spiel as far as I cannot be giving you legal advice. Also, every single week we post this live video on our podcast. So this is the North Carolina Real Estate Show. So you can go on Spotify or any of your other podcasting platforms and listen to the podcast. We cut out some of the random stuff, so like this won't be on there. So it's a little more clear and concise. So if you couldn't make it to the live, you can also go there. Also, you can subscribe to the YouTube channel. We put out one new video every single week. We're possibly going to add another video if we can find time. We also do a YouTube short every single day. So we have a lot of content going out trying to help real estate agents have a nice and easy and smooth closing. I do have one question for you that I got from somebody. They texted it to me. do you handle, like if someone had purchased a building, piece of land, property in their personal name and they want to switch it over to a business name?
Okay.
Do you handle that, and how is that done? What are the legal words of
Yeah.
how that's done?
So the simplest answer to that is yes.
Yes, I do
Um,
that.
so that's done by a deed.
Okay.
So you would deed the property from your individual name into your business name, whether it's an LLC, corporation, whatever it may be. There are things that we would want to know, like is there a loan on the property? Because if so, sometimes a deed of trust, well, I think they all do, have the due on transfer clause, meaning if you transfer the property, then the lender can call your note and say, you got to pay us. Um, sometimes that's simply resolved by calling your lender and saying, "Hey, I formed an LLC to limit my liability. I want to put the property in there. Is that going to be a problem?" And they can give you an answer on that. But there's questions we want to ask. But the simplest answer to that is yes, we do it all the time.
Yeah, can do. Can do. Next question. This is a general question that we know, but most people don't know. Who chooses the real estate attorney that they work with?
So it's the buyer's right to choose. We are so thankful to work with a great group of realtors that recommend us to their clients, and really, really glad to have that relationship and that your trust is put in us. But a lot of buyers don't realize that there's nobody that can make them go to any specific attorney. We had a guy come into our office and said, "Hey, my agent picked this attorney, but I don't know them. I do know you. How do I?" They basically were like, "How do I get out of my contract with that lawyer?" And I was like, "What are you talking about? What contract with that lawyer?" It's like, "Have you signed an engagement letter? Have you done anything like that?" And it was all no. It was just their name was written in on the contract. And I explained, like, ultimately it's your call. Like, you're in the driver's seat as the buyer. Um, we of course would be honored to be chosen or recommended by an agent. We'd love for buyers to choose us, but we think it's important that buyers understand they're in the driver's seat. They get to pick. There's no title company, no lender, no agent, no anybody that can make you go any specific place if you don't want to.
Yeah. You hear that, people? We're not selling you anything on this. We're just trying to help you guys be better agents. The buyer's the one that's actually our client, and we actually don't sell the buyers ever. We hope you do. So we do have a question here. They said, how about the opposite way? I don't know which part they were talking about. Once sold, what's the best way to get money liquidated to the owner or swapped into another piece or two of real estate?
I wonder if this is about okay, if you're
I think this was the redeeding to
an LLC, maybe going from LLC to your individual
Yeah,
name.
so I think like maybe they sold it as a business and now they want the money
Yeah.
because,
Yeah.
it's nice to make your own money.
Well, I promise this is not a
Yeah,
cop
LLC
out.
to owner, they clarified. Yes.
Okay. So this to me is more of a CPA question than a legal question, because the legal stuff involved in that is pretty straightforward, easy to do. All of the red flags to me become, what are the tax implications? So do you perhaps maybe need to do a 1031 exchange so you identify a replacement property? And
That's where my head went. Like, I'm not, a lawyer, I'm not a CPA, but like my head goes to, oh, if you're going to swap it out for another piece of two or real estate, then a 1031 exchange may be something that you're interested in.
Yeah. And here's the key to that we see a misunderstanding with people sometimes, is that if you are selling property and you intend to do a 1031 exchange, the whole purpose of the 1031 exchange is that you have a qualified intermediary that holds the money for you. You never come into possession of it. Once it's yours, you get taxed on it. So the idea is that the intermediary is the one that's facilitating getting the money out of the one property and helping you buy the other piece or two or whatever it may be of property. So you have to the property's got to be like same or higher value. Really, any of the money that you don't use on your next purchase, it's going to come into your possession. You'll be taxed. But you could defer that by rolling the funds into Again, doesn't have to just be one property. Say you
Can
sell.
you just give us like the quick and dirty of like what goes into a 1031 exchange? Like
Mm,
how long do you have before
mhm.
you can find a new property? You
Yeah.
know, how's that all work out?
So you have 45 days to identify the new property.
So just identify,
Yeah.
not necessarily buy it. You just have to say, this is the property that I would like to purchase, or do you have to have an offer in?
Yeah, 45 days to identify, meaning this is the one I'm buying. I'm under contract to buy this.
Under contract.
And then 180 days to close that.
180 days after you're under contract. Now, what if you
180 days from the sale, not from the contract. So
Gotcha.
it's,
So
the
6
scale is from
months-ish.
0 to 180. 0 to 45, you have to figure out what you're gonna buy, and then the 46 to 180 to close it.
Gotcha.
And that's
So
because in commercial, you have longer due diligence periods.
what if you're in due diligence, it's day 43, you find your property, you go, hey, you're doing your due diligence on day 80, and you're like, this isn't the
I
property.
actually don't know the answer to that.
Really?
Yeah, I don't know that. I've actually haven't dealt with that, so I haven't encountered it. I think if you were just doing like a strict reading of like the basics of, okay, well, you missed your window
That's what
to
I'm, yeah, like you
identify,
missed your window. What
but I
happens?
don't know if there is a loophole or some kind of grace for like, all right, you identify the property, but it's not a good piece of property. Yeah, I don't know the answer
We'll
to
have to
that.
look into that one. That's an interesting one.
Mhm.
I'm surprised it hasn't came up because,
Mhm.
but typically if you're an investor, you kind of just are like, yeah, I've already done my due diligence. I have my numbers that
Yeah.
I'm looking at.
Now, I wanna go back to the question that was asked, and that we got off into talking about 1031 exchanges a lot. I don't want to say that I'm endorsing that, like, that's what you need to do. I'm saying that's an option for
Yeah,
you,
talk to your
but
CPA.
your CPA might have different, a take on that, what is the best way to do it is not the best for everybody, it's the best for you, and your CPA looking at your specific financial situation is.
Yeah.
Yeah. So the legal part of that is super simple. Like, there's really not a lot that the lawyer is involved in, and like the liquidation part and helping you save money
Yeah.
on taxes.
And, just to kind of clarify, because you've had people that don't understand, and I don't fully understand. I just know it's like, hey, you need to get a bigger piece of property, with this money or
Not even the bigger.
oh, so it doesn't have to be
Here's an
more value.
example. So say if you want to use all the funds, like say you get 100,000 out of an investment property, you're using a qualified intermediary, it's
That's
now
the
it's
one I
time
want
to
to remind
identify.
people of, like, you don't get the money, the people don't get the money, the qualified intermediary, which is another person.
Yeah. Yep, that's right. So say you get 100,000 out that you need to put into replacement property. That could be a 25,000 and a 75,000, a 50-50. It could be 120. So you use all 100 and you add 20 more to it. And then you keep going
I
that
guess
way.
that's how I always hear people doing it, because they want to level up, I guess.
Yeah.
But it doesn't, I mean, a good
Yeah.
investment's a good
Now,
investment.
if you
Doesn't
get
have to be
100
more.
out and your replacement is 80, then it's the 20,000 that you didn't use is where you need to talk to your CPA about
Because that's where you'd be pulling it
what will you
out.
pay taxes on? Yeah.
Interesting. Got another one here. How long are prenup agreements, and have you ever seen any unusual clauses in any?
Yes, I have seen unusual clauses in them. And the ones that I'm thinking of might be a little too recognizable. I wish I could give the examples. I haven't seen some as nearly as juicy as our friends in family law have, but I've seen some unusual ones having to do with when one spouse may see his or her girlfriend or boyfriend, and where. Like, hey, you can have a boyfriend on the side, or you can have a girlfriend on the side, but they can't come to the house and they can't meet our kid. Like that's that stuff.
You can have a side piece, but you got to do it in the other county. I just don't want them in my county.
Yeah, I mean,
or whatever.
I mean, if they agree on the terms, you can do anything. And prenups can be really short and straightforward if there's really only a few things you need to talk about, or they can cover every scenario of like, if we break up because you did XYZ, then I get this and this. Yeah.
Interesting. What about property that's been inherited? What can you tell me a little bit about, like, inherited property with, I think they're wanting to know more about like the funds of it. Like how do you kind of navigate the funds of an inheritance? I know there's another CPA question,
Well,
but
that's part of it, but also it depends on how you inherited it. Was it by will, by intestacy, meaning no will? Because then the laws of the state of North Carolina are going to determine the shares and who gets what. But then you also have the issue of, okay, say 6 people inherit property, but one of the 6 people was the one who lived on the property, took care of the property, paid for all of the improvements. Well, if all 6 decide to sell it, but the one is the one that was out the most money and taking care of it the whole time, then it doesn't mean it has to be an equal 6-way split on the proceeds. The one that had, like, I've been paying the taxes, I've been doing
would
this,
they
I've been doing
argue that in court or with an attorney? Probably like a mediation kind of thing.
Well, if hopefully they never get to that point.
I
Hopefully
know.
they all sit down at a family meeting and say, "Listen, Betty, I know that you've paid all the taxes on the property. You've been living here. You spent all the money to fix it up. Since we inherited it, you've done all of the maintenance. You've done everything. So we're going to agree to split it up this way." The heirs can agree on. Again, it's just like in a prenup. If the parties are agreeing on it and it's not illegal to do that thing, you can agree to anything that's not illegal. So, and then as far as, again, we talked about the CPA thing of, depending on how you inherited it, maybe you get a stepped up basis, maybe you don't. There are ways to get a step up in basis, like if you inherit through a revocable trust or, whatever that may be. But yeah, unique situation. Every single one is unique.
Yeah, there's always some interesting stuff. With a 1031 exchange, again, when you're looking at the money that's come out, let's say I bought a house for $100,000, I put $20,000 down, I owned it for a while, paid down my mortgage a little bit, and then I sold it for $150,000. And so my initial investment of $20,000 plus what I've paid, does the 1031 take the entire sale of the house of the 150,000, or is it only my gain? So like, let's say I only gained $80,000 or, whatever.
Well, the purpose of the 1031 is to defer paying the taxes on your gain indefinitely until you pull the money out. So
what a 1031 does is defers the taxes of the gain.
Yeah, and you could do that. Well, as long as the program is,
so really,
as long as it's allowed by law, you can continue doing
you'd
that.
take your money out. You would basically, it would be reimbursing yourself for your initial investment because you're only deferring the taxes of the gain.
Like, for example, you sell for 100,000, you buy a property for 120. That by the time you sell the property you bought for 120 for 200, take the 200, put it into something. It can keep going.
Yeah. So it's just the tax on the gain. Someone was asking about the how that works, and it's a 1031 is an interesting one. There's a lot of investors that do it and believe it. But like you said earlier, it's really a CPA question because it's a great tool. It just might not be a great tool for your specific situation. If it is
your goals, so
it is a great tool. If that's what you're using it for, awesome. Because if you're going to be investing for the next 30 years, you're probably going to use 1031s pretty consistently.
Probably so.
Yeah. Any other ideas or things that have spurred you? Here's something, I know this relates nothing to real estate law whatsoever. You've had 2 full nights of sleep. And this is why you're so sharp today.
I don't know about that. Bless you, Kennedy. Our daughter, who is almost 1, slept through the night the last 2 nights. And for those of you whose kids sleep through the night and have since they were 3 months old, good for you.
Good for you.
we're
But you
not
know
there.
what? You are bright today, and you are chipper because you've had 2
full nights
of sleep. I mean, full.
Yeah. Trying not to think too much about my to-do list that's waiting for me upstairs.
Yeah.
But at least I got a full night of sleep to work on it all.
Yes. Any other questions, anybody? I know we got a few people hanging out here. Here we go. How do judges tell lawyers how to disperse proceeds in cases with equitable distribution?
That's a good question.
So I'm going back and forth. Here we go. This is live, people. We're back and forth.
So in the order. So generally speaking, when we're dealing with clients who are selling and they've got equitable distribution in place, then we're provided, and we can see it in the title search as well, the order stating who gets what. So if that is still pending, we don't have the order yet, then it may be that we need to wait to close until that's decided, unless the parties can come to some other agreement without the need of a judge that, maybe it's a consent order where they say, we agree we're going to do this. Judge, can you sign off on it and make it part of our case? If it wasn't addressed in the separation agreement or something else. So that the judge will have an order entered, signed by the judge, clocked in the file, and that's what we go by.
All right, here's another good one. This is a Ryan question. This isn't on here.
Okay.
You've done litigation before, so one thing that we can say, like, we will be adding real estate litigation back to our practice. So we did it a while ago, like sporadically when Ben was alive. Then we just got too busy, and like real estate closings are what we do. And so now we're another attorney, hopefully. Offer letter is out, but it seems like it's going to be very good. So we'll be adding back in real estate litigation. So first question is a normal question. What goes into real estate litigation? What is real estate litigation? What are some of the things that would happen that you would need to litigate about or would litigate about?
Like quiet title actions, say there's some cloud on title or title defect that needs to be resolved, and we know what the answer should be, but the parties are not playing nice, or say the party that would sign the document that would make this go away has passed away and there are too many heirs or the heirs can't be identified. Go to court, ask the judge to fix it for us. So that's one thing. And then, neighbor disputes come up all the time, unfortunately.
Ben's famous quote of, "Hey, just go talk to your neighbor.
Just go talk to your neighbor.
You don't need to pay me."
Yeah. I don't need to be a paid therapist. Just go talk to your neighbor. So neighbor disputes, things can come up with breach of contract actions. There's really kind of all kinds of disputes that are related to dirt.
Old dirt lawyers. Yeah. You're made fun of in the law community, but I sell dirt. It's the one thing that everyone wants. More dirt.
Yeah.
My second question to that is, when you're in court, you go to the
I'm
judges.
not dressed like this.
Yeah, you're not just like that. You go to the judge's chambers. What's it like in there? What's it look like? What goes down?
Depends on the courthouse. But there is a lot of like leather. There's a lot of leather. lot of bookcases. Usually the administrator has an office right outside of the judge's chambers, and you go in and there's books and files everywhere. A lesson I learned is a judge had offered me tea once and I declined, and the other attorney that was there with me, he said, next time he offers you tea, take it.
So I can't remember. I know you argued, you had a very large case, and I wouldn't say it's necessarily large of a case, but like in the legal world, like it's prestigious to go do what you did. Like I always butcher you're arguing in front of the judge or whatever.
The Court of Appeals.
Yeah. Yep. So yep. Tell us what that is, because I always butcher it. Like, what is the Court of Appeals? Why is that big? Like,
oh, well, the reason this stood out is because unlike the lower court, the superior court or district court,
lowly superior.
There's 3 levels. There are 4 levels, but really, district and superior court are housed in the local courthouse. You can appeal to the higher courts, so Court of Appeals, and then further potentially the North Carolina Supreme Court. But unlike in district or superior court, you don't really argue at those higher courts. So they usually decide everything based on the writings of the parties, so the briefs and the submissions and all of the evidence and everything that's in the file. So they'll review all of that and issue an opinion based on that. But if they see your file and they're like, maybe this is a new issue and we don't have a lot of authority to rely on in deciding this, let's hear from the parties, they may ask you to come and have oral argument. So that's not, it's not common to go have an oral argument at the Court of Appeals.
You did it.
We won.
And you won. You did it and won. Want to
Well,
know.
I should say we got a favorable result in the appeal.
It's a win.
And then I stopped doing litigation before that case was finally resolved, but they won the trial too.
Good job, people. So any other questions before we hit the road out of here? We're going to record some YouTube videos. So also, if you have any other topics you would like discussed in more depth, we can add that to our YouTube list. That's what we're getting ready to do here, but we appreciate all the questions. Definitely.
Yeah, thank you. It was nice to have some questions.
Yeah, more enjoyable to answer questions than just talk about one topic.
I always feel bad whenever the answer is like, oh, it depends, or we need to talk to a CPA. But, that's what makes a lawyer's answer reliable, is that
because it always depends.
when they don't have any, stipulations or whatever, then, they've thought about it. They know that it's something in their subject matter, but we have to be able to point to other professionals whenever we don't have that subject matter knowledge. I'm not a tax lawyer. I don't ever intend to become one. So I want people talking to people that, know more about it than I do.
Yeah. Awesome. Well, we appreciate everyone coming and listening. We're going to start doing this. I say start. We've been doing it. We're going to continue doing the live. We like the live. We just don't have much time, either of us. So for us to record this live, it definitely is helpful for our schedules, and we enjoy it. So when you guys have questions, if you want to get on here, always going to be Monday. Fingers crossed, 10:45. Sometimes it might be 10:50. Sometimes it might be 10:40. But right around that 10:45 time, it's our marketing block for the law firm. So that's when we do our podcast. And hopefully there'll be more people than just me. It's just, this is my office. So this is why you get me right now.
You're our producer.
Yeah.
I'm a hype man.
Yeah. Great. Well, we appreciate everyone listening. Make sure you like and subscribe, and we'll see you next time.
Bye.